Hi everybody, and welcome to this event that we're putting on this evening. Thank you for taking the time to join with us and connect. Welcome to the session. My name is Elaine Hutley. I'm a partner in the employment team here at Irwin Mitchell. I'm also joined by Dave Stubley and Alex Thompson, although they're not on screen at the moment, but they will be joining in throughout the session. So the topic for today is employment status. And for those of you who weren't aware, we are doing another session next week on volunteers and 0 hours contracts. So I'm going to avoid those subjects today. And if you notice that that's missing, that's the reason why. Please do join us for session 2 next week. Just by way of housekeeping before we start the session, huge thank you to everybody who's already submitted questions. We've tried to weave that within the contents of the presentation, but if you do have any follow-on questions or we haven't quite answered the specific question that you were raising, we have the chat function as part of the event. Likewise, if you haven't already submitted a question and you want to, please do. We like these sessions to be as interactive as possible. We'll try and pick them up as we go along, but if not, we'll be doing a Q&A session at the end as well. If we're inundated, because you've all got lots of burning issues, then we might not be able to answer all the questions during the session. So when you include your question in the chat, could you just include your name and email address, and what we'll do is pick up with you after the event to make sure that your query is answered. Now, we are recording this session, and a copy of the recording will be circulated afterwards. And towards the end of the session, we'll also be posting a live feedback link. So please do take a minute or two to fill that in. And that just makes sure that we make sure future events are relevant to you and your club. Okay. So please do ask as many questions as you can, just as by way of heads up as well. We are going to be running some Q&A during the session to test what you think about employment status. We want to gauge any preconceptions that you might have, and we're doing that via Slido. And in just a second, I'm going to put up details so you can get your phones at the ready to join in on those. There's no naming, there's no shaming. It's just really so that you can let us know what you think and see what the consensus of opinion is as we go through. So they're on the screen. Please do join in those polls, completely anonymous. So while you're just doing that, why should you be bothered? Why is it relevant for you to understand employment status? My slides are going slightly off kilter, but they'll catch up in just a second, so please bear with me. So it matters because under employment law, we have 3 different types or 3 different categories of employees or workers. So we have at one end of the spectrum employees. That is, if you like, the gold-plated standard. They have full employment rights and they have the most protections under employment legislation. At the other end of the spectrum, we've got self-employed. So those are people that have little protections. They're in business on their own right. They carry their own commercial risk. We have limited, if any, obligations to them other than what it says in our contractual arrangements with them. And then in the middle, you have what are called workers. They aren't the gold-plated standard of protections that employees are over on this side of the spectrum, but they do have some rights and protections. And so it's really important at the outset of any relationship that you understand where individuals sit within that spectrum, because without that, you might inadvertently and mistakenly fall foul of your obligations, which can then result in litigations and claims. Okay, hopefully everybody's still with me at this point. The slides have managed to keep up. So why should we be concerned about it from an RFU point of view? Well, there's a number of reasons. First and foremost, we were working with, oh, my slides have gone crazy. We were working with the HMRC, who came in to do an investigation, and it wasn't actually around employment status, but they made not a throwaway comment, because it was a pertinent comment, and that's what we've included on screen there. So they made an observation to say, we do have a secondary concern that many clubs may have incorrectly determined the status of their director of rugby, head coaches as self-employed, etc. So if you want, I mean, HMRC are incredibly busy at the moment with the furlough scheme, but at some point they might loop back round and say, this was on our agenda and now we're going to have a look at it. So we've got a window of opportunity to say, are we getting to grips with employee status? As I also mentioned, you've got compliance and contractual issues. So are your employees on proper employment contracts? Are your workers on proper worker contracts? Have we properly identified self-employed? You've also got to ensure that you're complying with your statutory obligations. So have you properly identified an employee or a worker who would, for example, be entitled to national minimum wage, the right to holidays, etc. And then also, hopefully, you're all familiar with this document that's available on the RFU website, but there's the issue of material benefit. So are you identifying what benefits you're providing to your players, your coaches, etc., as to whether it's material or non-material? Now, one thing that sometimes complicates the situation is that if we talk about the HMRC investigations, I've just said to you that under employment law, we have three categories: employed, self-employed and workers. The tax office and HMRC don't have that distinction. They have either employees or self-employed, and that is confusing. That conflict between tax structure and employment legislation is causing lots of difficulties at the moment, and I suspect it will be picked up at some point in the future as a result of all the cases that have emerged over the gig economy that we'll come on to in a second. But at the moment, you could have a situation where HMRC say that someone is self-employed, but actually under employment legislation they could be a worker. And I say that to you now, I'm not going to give you a lesson in tax. I couldn't, I'm not a tax lawyer, but just to say, just because someone might be filling in self-employed assessments and accounting to the revenue doesn't mean that at some point in the future they couldn't claim to be an employee or a worker. So just bear that in mind when we're doing our audit and our investigations internally to identify status. So what does it matter? We have lots and lots of different titles. So even though I've just said to you we have employed, self-employed and workers, actually there's lots of colloquial terms. So agency staff, 0 hours workers, employees, perms, temps, volunteers, casuals. To a certain extent, all of those could be interchangeable. You just have to identify your three main categories. So whether you refer to someone as an employee or a worker colloquially, or staff across the piece, as long as legally you know which individual falls within each category, that's the crucial bit. And likewise, because of that, just because you call someone, for example, self-employed, and you have a contract with them as self-employed, doesn't mean that in the future the tribunal won't have a look at it and say, well, we understand you've called, this person self-employed, and maybe they've even called themselves self-employed, but we're going to look beyond that title or that label, and we're going to get to grips with actually what their status is. Okay, so what really counts is the actual nature of the relationship, which we're going to come on to have a look at, and not just the label that we might have put on it. And also, I think it's important to bear in mind that sometimes you can enter into a contract with someone and then the nature of the relationship changes. So if you've taken someone on, for example, as a worker, working maybe on your bar or as a steward, and you use them when you need to, but then over a period of time, actually they become that key member of staff, and they're your go-to person, and they always come up, and you know that they're going to be there at the game on the weekend, you're going to be there at the training. They might have started off as a worker, so this relaxed, flexible arrangement, but then at some point they've become an employee, and that's because your contract can become outdated. We should review them, but just because you identify the status of someone at the outset doesn't mean that that can't change over a period of time. So always be live to that. Okay, and we are going to look at the factors in a moment. But before we do, we thought we would do a litmus test. So please have your phones at the ready, because we're going to have our first Slido question. And this is really just to, as I say, a bit of a litmus test to say, what do you think now, before we start this session, the main factors are to determine employment status? As I say, this is completely anonymous, so you don't have to worry about getting the answer wrong, and it's just going to be a bar chart. So hopefully, as you all participate, and please do, otherwise I'm going to sit here with a blank screen, which could be a little bit embarrassing for me. We're just going to see which one of these you think are persuasive in determining employment status. Okay. Great, looks like our Slido chat's working, so thank you for those who've already answered. So far we're 100%. Oh no, we've got others. Okay, let's just give it a couple of minutes, see where we get to. Okay, can I have 2 more? Can you get me up to 10 people? Yeah, there we go. Right, this was actually a little bit of a trick question because there's no right or wrong answer on this. So on some of the others there will be an answer, and I will give you an answer, because the truth is, around employment status, there isn't one factor that will absolutely determine it. So checking someone's status isn't like having a list and saying tick, 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 you are definitely an employee. There's lots of different factors that are all taken together. One of the key ones, actually, you've resoundingly got it, is who says what they do and how they do it. So there's that degree of control, supervision, work delegation. That is a one important factor. But actually, one of the most crucial ones is the requirement that the individual, to be an employee, has to provide personal service. And what that means is, if I'm your employee, it's me that has to come in and do the work. I can't sit at home and think, gosh, the sun's out, I want to sit in my garden, I'll send someone else in my place to do that work. It has to be me, and it has to be me, the personal service. Another big factor is there has to be what's called a mutuality of obligation. So that means I have to be given the opportunity to work as an employee. So there's an obligation on the employer to provide me with the work. And then once that work's been provided, the personal service comes in, so I have to be the one to do it. If there is a more flexible arrangement, so if there's work available but I can volunteer to do it and I can take it or leave it, you don't have that mutuality of obligation. So it's a commitment on both sides to enter into that employment relationship and for me to personally do the work. The third one there goes back to the Slido response, to say the employer has to have control over the employee. So an employee doesn't really have a huge degree of discretion or choice into what they do and how they do it. So they have to be there at a certain time, they have to undertake certain tasks, and for those to be completed. So there's a degree of control there. And also the tribunal will look at not necessarily the label solely, but they will look at the contractual terms to see whether those are consistent with employment status. Now, it doesn't mean if they're not there that actually the tribunal won't say, well, the way, you're not an employee, because the tribunal will look at not only what's written in a contract, and we'll come back to this in a minute. There was a case, you will have all heard of it, around Uber, and a lot was made about their contractual terms. So the tribunal will look at what's written down in the contract, but they'll also look at the conduct of the parties to determine what the contractual terms are. So by your custom and practice, have you behaved as an employer an employee. Okay. And then I was a little bit cheeky on the Slido question, because I did say things about, you know, who pays for the uniform. Again, that's not a determining factor, but that also comes down to control. So how do you present that individual to the outside world? You know, if you have someone in your uniform and if they are saying that they are your representative of your club, then again, that's consistent with an employment relationship. And if you're providing the tools of their trade, so uniform and the equipment that they need to do their job, is indicative of an employment relationship. Now, at the beginning, I did say that employees are the highest, like the gold standard in the employment relationship, because they have the most rights and the most protections. So on this slide here, and you can have access to this afterwards, so you know, it's a useful overview slide to say, well, what are those rights and protections? Unfair dismissal is obviously the key. Once an individual has 2 years employment, 2 years service, you can only dismiss them for a handful of reasons, and you have to follow a fair process. So that's normally the gold-plated right. But then there's also the right to family related leave, so adoption leave, maternity leave, paternity leave, etc. They're entitled to a redundancy payment. They're also entitled to a minimum notice if they are being dismissed, so even, which is 1 week per completed year's service. So even if your contract says they're only entitled to, say, a month's notice, but they've been with you for 8 years, their statutory minimum notice periods trump what you say in your contract. Okay, so employees are the most protected, so it's really important that you identify who your employees are to make sure that you're not falling foul of any of these obligations and protections. So we have another Slido question coming up. I meant to make a note of how many we had answering the first one, and I forgot. So please, everybody who did answer, join in for this one. If you didn't, please join in for the next question. So we're just getting them on screen now. So, and this is about your employees' obligations to you, actually. So it's, if an employee wishes to terminate their contract of employment, so they're resigning, is it true or false that by law they have to give statutory or contractual notice to their employer in writing? So we've got, so far, we've got false. So they wouldn't have to, or with split 50-50. Okay. Okay. Just while we wait and see if we've got any more answers coming in on that. Employees, there was a change in law in April. And with everything that's going on with COVID and sort of isolation, it sort of went under the radar because it came in at the beginning of April. So historically, for any employees, you had 2 months from when they started with you to issue them with a contract of employment that complied. There's a minimum amount of information that you have to include in a contract of employment. On the 6th of April, that changed, and it's now what's called a day one right. So if you take on a new employee, you have to provide them with a compliant contract, even if, for example, you've only taken them on for a month. So there's no minimum service requirements. You can do it in advance, so you could, when you send them the offer letter, send them a copy of their contract, but as an absolute minimum, they have to have it back on day one of their employment starting. If you don't, and the individual were to bring a claim in the tribunal, they could tag on an extra claim to say, well, I wasn't issued with a what's called a Section 1 statement, which, because it's a requirement of Section 1 of the Employment Rights Act. And then and if that's the case, if you haven't given them an employment contract, they can get between 2 and 4 weeks compensation just for an admin oversight. Now that's for anyone that you take on from the 6th of April. If you've already got employees, one, just double check that your contracts comply and provide the minimum information. If they don't, you'll need to update them. but your requirement to provide an up-to-date Section 1 statement or contract applies once an existing employee makes a request. So for everyone you're taking on now, make sure you've got a contract ready for them on day one. For any of your existing employees, just know that if they request it, you have to provide an updated contract. Okay, so going back to our Slido question, an employee wishing to terminate their contract of employment must by law give statutory or contractual notice to their employer in writing. By law under statute, not. So those of you who said that's false, you are absolutely right. However, if your contract says that notice has to be given in writing, then yes, they would. So you're both kind of right. Another tip is actually to make sure that your contracts have the provision saying notice has to be given in writing, because if you don't, there is a possibility that if someone, for example, comes to you in the heat of the moment and says, I'm resigning, I'm leaving, there might be ambiguity around that, and you have to be careful how quickly you respond and accept a resignation that's given in the heat of the moment. So having that requirement that they have to do it in writing just takes away the error of doubt and gives you a little bit more certainty. Right, the other point to note about employees is that sometimes they can be employed under what's called an umbrella contract. So if you take someone on, for example, in your bar for a season, and then at the end of the season they go off, that could be the beginning and the end of their employment relationship. However, if towards the end of the season you think they've been an absolutely brilliant employee and you want them to come back at the beginning of the next season, so there's a degree of certainty, you know they're coming back, you know on what dates, then actually those two periods of employment could be put together and linked. Now, the bit in between, so in the off season, won't count towards their continuity of employment, but it does mean that there's an ongoing or umbrella employment relationship. So it's just worth bearing that in mind if ever you are dismissing someone, for example, if they've returned season after season and you've always known before the end of one contract that they're coming back at the beginning of the next season, because they might be able to tag all those together and say, well, actually, I've got the right to claim unfair dismissal, because even though I've only been employed in each block for a few months, however long that was, overall, if I've been coming back for numerous seasons, I've got my 2-year service to claim unfair dismissal. Okay, but there does have to be a degree of certainty about it. So if one contract ends and you just have absolutely no idea when or if they are going to be coming back in the future, that probably will break. But if it's planned, if it's known, and if it's certain that they are going to be returning to you, then they potentially will have continuity of service. So that brings us to the end of employees. I'm just trying to see if we have any questions that it would be good to deal with. So I'm just, if you bear with me one moment, if anybody's keeping an eye on the question, Dave and Alex, are there any that you think will be worth picking up at this point? Okay, no, I tell you what, let's carry on with workers, and we'll go through the questions in the background, and then if somebody wants to act as question master for me, that would be great.
Yeah, I think sorry, Elaine, just to say that there are a couple of questions. I think we'll deal with them towards the end.
Okay, no, that's absolutely fine. Right then, so we've started at one end of the spectrum with employees. We're then going to move on to the middle pool, which is a worker. So if you think of it in this way, and I mean no disrespect to workers when I say this, if you think of it as being almost a dilution of their rights and protections and also our obligations. So in order to be a worker, the individual still has to work under a contract. There has to be a mutuality of obligation when they're working. So if, for example, I have said I am going to work as a steward at your grounds and I'm available for the next 3 weeks, then if I'm offered work and I accept it, then I'm under an obligation during that 3 weeks to come in when I know the games are on or when I know you need me, because I've accepted that assignment. But once I get to the end of that 3 weeks. If I then wanted to go on a 6-week holiday, there's no mutuality of obligation at that point, because I've just said I'm not available and I can go off for as long as I want, and I make no commitment to you beyond that first 3 weeks. So there's a mutuality of obligation when I'm working, but when I choose not to work, I'm free as a bird. With being a worker, I still have to provide personal service. So if I'm saying that I'm going to come and work for you, I am obliged personally to come and do that work. I can't send a substitute or somebody else in my place. But generally, it's a lot more flexible. It's a lot more fluid, and there's no obligation on the club to offer me work if it's not available. Or you might say, we've got 10 stewards, we need 3 for this game, who's available? You don't come to me personally, it's just thrown into the ether and we all pitch in initially. So there's been a lot in the press over the last sort of 2 years, because this is around the gig economy and the flexibility. So the cases that you might have heard about and read in national press about Uber, Deliveroo, Pimlico Plumbers, was all around the businesses have tried to label these sorts of individuals as self-employed and saying, well, actually, we don't owe you any obligations, you're in business on your own account. And the individuals tried to argue themselves into this status to say, well, I can't be an employee because, you know, I do have an element of freedom. But actually, you know, when I'm an Uber driver, if I sign onto that app, then I'm committed. We've got this mutuality of obligations during the period that I'm working, and I do provide personal service, and I am under a contract with you. So actually, I'm not self-employed. I'm a worker, and I deserve certain protections. Okay, hopefully that all makes sense. If not, and if you've got any questions on that, because it is a really complex area, so please do pop them in the chat function. So just by way of summary, as you can see, the slide that we had for employees much more populated with their protections. These are the protections that we have for workers. So some of them are similar and exactly the same as for employees. So protection from discrimination, that applies to employees and it applies to workers. The same with whistleblowing, the same with national minimum wage. There's still the right for paid holiday and rest breaks. So the working time regulations apply to workers as they do for employees, but there's a lot of key ones that are missing that employees have that workers don't. So again, we're just going to do another Slido just as a litmus test to say, do you understand the protections that are available? So this one is around holiday. So a worker and an employee are both entitled to statutory minimum holiday under the working time regulations. But do you know off the top of your head what that entitlement is? So is it 4.8 weeks, is it 5.2, or is it 5.6? Okay, we haven't got as many answers, so I'm just going to let that one run while you just have a think about it to see if we get any more answers trickle in. Now, and I'm going to pick up actually on national minimum wage, because that's also a right of employees and workers. And that might come back to the HMRC's comment about, have we properly identified where our coaches, for example, are workers rather than employees? So national minimum wage, the rates depend upon the age of the employee or worker, and it's calculated by reference to the hours of work that they do. So from the time that they start work to the time that they stop work, whatever they're paid is then divided by that number of hours to give you the hourly rate. which is why you do need to be careful to make sure that you identify your proper workers. So we've got another Slido question coming up, but I'm just going to give you the answer to this one, and it's 5.6 weeks. So if you've got somebody who works full-time, for example, 5 days a week, it's 28 days, it's 20 days plus the statutory 8 bank holidays, but yeah, 5.6 weeks. And a week is whatever they would normally work. So if you have someone who works 3 days a week, they get 5.6 of 3 days a week. And holiday and holiday pay can be incredibly complex if you've got people who do, for example, annualised hours or term time only working or anything like that. So it is an important one, maybe after this session, to go away and have a think about, are you properly accounting for people's holiday? Well, firstly, have you properly identified them as workers entitled to holiday? And then secondly, do you understand how that 5.6 weeks is calculated? So just to go back, oh, I've got someone who's eager already. Just to go back to that point on national minimum wage. So there is, in the context of the RFU, quite a complicated question that says, well, actually, if you've got a coach who is paid a certain rate for an away game, how do you calculate to make sure, if they're a worker, that you're properly paying national minimum wage? So when do they start and when do they finish work on an away game? So your options are when they leave their home club and when they return to their home club, when they arrive at the away game when the warm-up starts and the game finishes, or when they arrive at the away game when the game starts and when the game finishes. So I'll just give you a couple of minutes to have a think, not minutes, you'd have dead air, a couple of seconds just to have a think about that and add in your answers. Okay, this one must be a tough one, so we've only got 7 people, 8. Right, we're going up. Right, I'm going to give the answer away. So actually, you're all 100% right. Normally, the time spent by a worker travelling to or from their fixed place of work, so if it was an away game, if it was a home game, any time that they spend travelling from their home to the grounds wouldn't count as working time, because that is a commute to their fixed place of work. And they're not working during that time. They're not at the employer's disposal. They're not carrying out their activities or duties. But the position is different when that individual, when that worker has to travel as part of their job. So this would include away games for you. So if there's any time spent travelling as part of your job, and some of the guidance that the government issues thinks about sales reps, but it's a similar situation here, or if you're travelling outside your normal working hours, then it will constitute working time. So then the question is, well, do you have to be paid for that time when it's working time? And there's 2 parts to this answer. Yes, in terms of national minimum wage, so you always have to ensure that your workers are paid national minimum wage, and that will include travelling time where it's not to their fixed place of work. But do you have to pay them travelling time as part of your contractual payments? No. So what that means is, say you paid a coach £200 to go to an away game, but you calculate that by the amount of time they're at the away game. That doesn't mean you then have to pay them the equivalent hourly rate on top for the travelling time. I'm not suggesting that, but what you do have to make sure is whatever sum you pay them as a fixed fee exceeds the national minimum wage rate for the entire time, including the travelling time. Hopefully, if any of my other panel members think I haven't properly explained that, please let me know, or if anybody who's attending hasn't, we want me to approach that in a different way, please pop it in the chat and I'll go back over it again. But what I'm saying is, in a nutshell, as long as whatever you're paying for away games complies with national minimum wage, you don't have to increase the amounts. And just so you know, from the 1st of April this year, national living wage for 25-year-olds and over was £8.72. For those workers who are 21 to 24, it's £8.20. For 18 to 20-year-olds, it's £6.45. For 16 and 17-year-olds, it's £4.55, and for apprentices, it's £4.15 per hour. So they're your national minimum wage rates. So as long as you divide the entire time and you are exceeding those levels, you're fine. You don't have to make any extra payments. Okay, so that is that's our section on workers. So we're going to move on now to look at self-employed. So as I said at the beginning, this is more of a commercial relationship. The self-employed individual is in business in their own right. So there's a degree of commercial risk for them, and they carry that risk, and they contract with you as a club almost on a par. So employees and workers are generally have got reduced bargaining power against the employer because there's that element of dependency, of mutuality of obligation. They potentially could be at a disadvantage. They don't have the power to hugely negotiate terms. Whereas actually when you enter into a contract or a relationship with someone who's genuinely self-employed, they do have better bargaining rights because they're on a par with you. Some of the key components of identifying someone who's self-employed, as it says on the screen there, is that there's no requirement to be offered or accepted work. In the same way as I would at home look for a plumber, I don't have to go to one person. The market is there, and I'm free to contract with whoever I want. Likewise, my plumber is free to contract with me or turn down work. He's not obliged to come in. So there's an independence there. There's no requirement for personal service. So you might contract with someone who's self-employed, and they might, under the terms of their contract, say, you know, we will, as a company or as an entity, come and be your head coach, but actually it doesn't have to be that individual that you're speaking to. They could substitute somebody else. And we're going to come on to, well, what is the right of substitution, and how as a club do you manage that risk? Because actually you don't want to contract with someone who's self-employed, who's absolutely brilliant, got all the best references, got that track record, you know he's going to deliver, and then he sends someone completely different. So there are ways that you can minimise that right of substitution to make sure that you are protected, but there should be a right of substitution. There's also, and this is where I said earlier about commercial risk, so a self-employed person will be paid on completion of the works. So there's an element of risk there of they're not guaranteed a salary, they're not guaranteed an hourly rate merely for being present. They'll only get paid if they do the job, and arguably if they do it well. And those payment terms should be clearly set out of exactly what they are being paid for, and what they have to demonstrate they've achieved for payment to be received. The fact that they've got no direct supervision comes back in the employment relationship to that element of control. So if I'm an employer and I've got an employee, I will tell them what to do, how to do, when to do it. That isn't there, or certainly not there to that extent if you've got someone who's truly self-employed. You tell them that a job needs to be done, but they have control over when, how it's done and completed, and by who. There's also the ability for someone who's self-employed to contract with other organisations, so they're not fettered. They're in business on their own account, and yes, they might contract with you, but likewise they can go and contract with other people and do work for them as well, as long as it doesn't mean that they breach their obligations to you so they can't perform what they've agreed to. They are free to go and contract with other businesses or other clubs. And they also, because there's that element of independence and there's a lack of control, generally they'll provide their own equipment and materials. And likewise, if they suffer a loss, well, they're not going to come to you and ask for any sort of compensation or handout or help. You know, this is their business, it's at their commercial risk. And if they don't conduct their business properly, then, you know, on their head be it. So we've got, just thinking about what factors we have to take into consideration for someone who's self-employed, we've just got another Slido question coming on the screen to say, true or false, a self-employed contractor must have more than one client to be deemed self-employed by HMRC. What do you think? Oh. Right, we're starting to have these trickle in. Okay, more cautious on answering this question. The answer is false. They don't. You can just have one sole client, and it might be, you know, as long as all the other factors are present, so no mutuality of obligation, I can decline work if I want to, even though you're my only client, and you won't control who I am, you know, what I do, I can send substitutes. It does help if ever you are being investigated as a self-employed contractor by HMRC. If you can point to multiple clients, you might get a bit of an easier ride, but it isn't a requirement. You can, as a self-employed person, have just one client and still be self-employed. Okay, so why has this all become such an issue? As I said a little while ago, a lot of it has come out of some cases that actually gained national press attention. So we've got Uber. So they classified everybody as self-employed drivers, and this is the importance of contractual terms. It's probably most important in the Uber case, because Uber had an army of lawyers, and if you'd read their contractual documents, they all absolutely said that everybody they engaged with was self-employed drivers, and they said, we're not a taxi service, we provide a platform, we provide a product. We're not a taxi company, we're actually in IT. We provide the platform, and the drivers are self-employed, and they go off and they do what they do. And they got an absolute lashing in the courts. And what the court said is, you can't hire an army of lawyers and come up with some fandangled fancy contracts if the reality of the situation isn't reflected by those contractual terms. So the court, the tribunal and the courts were saying, we're not going to be dazzled by clever words, when actually the reality is, you didn't just provide Uber, you didn't just provide the technology and the platform, because you provided the interaction. Because as a passenger for Uber, I didn't go to the driver, I had my app that went to Uber. If I wanted to rate the driver, I go to Uber. If the driver doesn't get enough satisfaction rating surveys, he can then be stripped. So actually the driver in that situation is really dependent on Uber, but not so much, if we go back to the employment test, that they were employees, because they're not at that high level. The Uber driver can decide which shifts they want to pick up and when they log on to the platform. So they were never going to be employees, but they did successfully argue to say, we're not genuinely self-employed. We are in a weakened position against Uber, because we have to be, you know, they process payment for us, they process the booking, they tell us the route and how we go, they process the feedback that we get. We are workers. So that's probably the best example of saying, you've got to make sure that your contractual terms properly reflect what's going on in practice. Another one that you might have seen, it, which is the face of our chap there, was Pimlico Plumbers. They had an individual a plumber who was signed up under the Pimlico name, and he was with them for years. And he got into I think he reached his 60s, and he needed to have time off for a heart operation, and they terminated his contract. And they tried to say that actually he was never a worker or an employee, he was self-employed, and that's what his contract said. But again, the courts, and it went all the way up to the Supreme Court, Pimlico Plumbers said, well, actually, if we look at the reality of it, he only works for you, he wears your uniform, he drives a van that says Pimlico Plumbers, he'd never taken any time off, he always went where he needed to go, and did the work he was told to do in the way he was told to do it. So again, the fact that the contract said he was self-employed, the tribunal looked beyond it and said, no, actually, you know, we're talking about worker or employment status. And why should you care? Well, actually, these are really significant decisions, and it's the same with City Sprint and the couriers, the same principle, because now all of those individuals who were wrongly classified and were workers have claims for backdated holiday pay, national minimum wage. You know, HMRC are coming after those businesses for tax and NI contributions. So it has a huge financial impact on the business.
Elaine, can I just step in there for a moment?
Yeah, of course, please do.
So just to be fair, we'll get to some of the questions in a minute, but there's been a number of examples across sports clubs and rugby clubs specifically where the status of the individual has been wrong, and therefore HMRC have come down and provided, you know, as Elaine said, basically put the tax and the costs and any interest onto the club. So it is really quite important that in this area, that if you are looking at it, you get the status right. Thanks, Elaine. You're muted at the moment. Elaine, you're still muted.
I seem to be automatically muting. Right, so as Dave said, it's really important that you identify where you have got people who maybe we're describing as self-employed and actually they're workers. But also, I'm just going to pick up on one of my earlier comments to say, well, what actually if you have got someone who's properly self-employed and maybe you've just had alarm bells ringing because I've said anybody who's genuinely self-employed doesn't have to turn up personally to provide the services, and they can send somebody else. So the next slide that's going to come up looks at substitution clauses, and this is taken from the Pimlico Plumbers case, because there was a huge analysis then to say, well, how do we look at substitution clauses, and where is the cut-off point between saying someone is a worker and someone is self-employed. So if you have these in any of your self-employed contracts, or indeed if you're worried about workers' right to substitute, this is where we kind of draw the line to say if someone is a worker, they might have a limited ability to substitute work, but only when they're unable to. So for example, if they're ill, if you have a delivery driver who has signed up to take a shift and can't, they could send someone in their name. But someone who's self-employed, it's not dependent on their personal circumstances. So if they just choose not to, whether they're ill or they just can't be bothered, they've got an unfettered right to appoint a substitute and send them in. Sometimes with a worker, there might be a provision built into the contract to say, well, we will consider allowing you to send a substitute, but you have to get our consent first. So we've got a right of veto if any worker tries to send someone else in their place, and that is my right of veto to stop a worker substituting is absolute. I don't have to be reasonable. I don't have to say why. I can just go, absolutely not, I'm not accepting that. For someone who's self-employed, and this is where you can have some protection if you genuinely want to go down the self-employed route, is to say someone can have a right of substitution, but it's not entirely unfettered, because actually if you send a substitute, I have a right of veto if your substitute doesn't have the qualifications or the experience to perform the work. So there's a guarantee there of an element of quality and consistency. So someone who's self-employed has the right to send a substitute as long as they meet certain minimum requirements. That could still leave us in the self-employed category. It doesn't have to undermine that status, but it does have to be a very restricted right of veto on me to refuse a substitute. And And you can have across both categories, which is where sometimes the guidance that's provided by courts can be a bit confusing, to say you can have a conditional right to substitute, but it won't necessarily take one out or the other. What the courts will do is look at the contractual clause itself to say, is it an absolute veto, or can I only exercise my veto as the employer in certain limited conditions, and also how often is it used. So if I have a contract with an individual that includes the right for them to substitute, but they never have, they've always provided personal service, that contractual clause isn't particularly going to help me in arguing that that person is genuinely self-employed, because we've never acted on it. Okay, does that hopefully make sense for everybody?
Elaine, can I ask a couple of questions? I know we're going to go on to a couple of things, but there's just a couple of questions that have popped in, if that's okay.
Yeah, of course.
So I've got a question in the chat about if a person has a notice period. Sorry, I'll rephrase that. Having a notice period for our self-employed coach, does that mean he is actually an employee? I mean, it's a very specific question, but does that raise any concerns?
No, it doesn't. I think if you take a self-employed coach on and they genuinely meet all of the requirements for the self-employed test, and then they've got a notice period, it doesn't undermine it. What I would say is I'd be surprised if you have someone who's genuinely self-employed, because they're meant to have that level of independence. If you were telling me, for example, they got a 12-month notice period, that might make me a little bit, not necessarily uncomfortable, but to say we'd have to really justify why that was needed, because that builds in an element of security, I guess, but not one factor will be determinative. So if you think of it as a spectrum, and you might have some elements of the relationship that are definitely self-employed, and then you might have some that stray towards the, oh, could that be an indication of worker? It doesn't mean that those undermine the others. It just means we have to look at it in the round.
Okay. How about another one here from a club? We pay our head coach a retainer as an employee. He's expected to attend matches and training, but has no minimum hours specified. Is it okay to leave it to the employee to ensure his pay equates to minimum wage?
No. So as the employer, you are under an obligation. It's your national minimum wage obligation. So what I'd recommend there is that you do an audit and think about how you can access that data. So how are you monitoring his hours? And that's not only important from national minimum wage, but also in working out what his holiday entitlement and also his holiday pay is. So you should have a way. It's fine to have a 0 hours contract to say that there's no minimum, and we'll cover 0 hours contracts next week. But that's, as any sort of minimum contractual obligation is your minimum, you should still be tracking the hours that they're working.
Okay, I'll add one last one at this stage, and I'll add some at the end. Just picking up one slightly different. We pay the club manager or club steward, if that's the right terminology, as self-employed. She has no set hours and kind of does what she likes, apart from having the bar and kitchen open at certain times. Is this okay, or should this be labelled as a worker employee?
I think my very high level gut instinct on that is, if you go through the checklist of what your expectations of her are, in terms of, I'm presuming she manages the staff, I'm presuming she ensures the ground's open, I'd be interested to know whether, for example, she's got any health and safety obligations. With all that in mind, that I suspect she's probably in the worker or employee category. So, and I'm not saying that for sure, you know, to do this requires quite a detailed analysis, but my gut instinct says I'd be surprised if genuinely they were self-employed, and it would be worth doing a bit of a mini audit to see what the expectations are. So could that person genuinely not turn up on match day or not do anything to prepare for match day?
Yeah. And okay, final. This one's from me, really. In terms of the self-employed approach, is that, Elaine, would you normally expect someone who is genuinely self-employed to be carrying their own sort of public liability insurances as part of their business? Would that also be a reasonable indicator of that they are legitimately self-employed?
Yeah, I think it is, because actually that's where it comes down to commercial risk. So are they truly independent, and would they be responsible in their personal right if something were to go wrong, and have they thought about that and then built in their own insurance to give themselves protection? If they haven't, because they'd be reliant on your insurance through the club, again, that takes away an element of that independence. So it's certainly something that helps to demonstrate that actually they've got liability and cover in place.
Okay, I'll do some further questions at the end. Thank you, Elaine.
Okay, well, we're almost there. So the next point is just to say, hopefully this hasn't baffled you all too much. It's given you lots to think about. So what do you do next? Tomorrow morning, when you sat back at your desks, what should you plan to do? The first thing has got to be, have a look at the people you're engaged with, and then have a think about, have you properly identified those who are employees, those who are workers, and those who are self-employed? And as of next week, when we go through that session, who are your volunteers? Once you've identified which pod they sit in, then have a think about, have you got the correct contractual and documentation in place? So have you got a contract that's appropriate to employees that meets that minimum requirement? So it's on hand as a template. You can issue it on day one of anybody else that you take on. Have you got a proper worker contract, so that, and the danger is, if you use one contract for employees and workers, your workers might point over and say, well, I am an employee because look, we're on the same contractual terms. So you might have a slightly simpler one for your workers. And then have you got proper arrangements in place for your self-employed contractors? So for example, do they include a requirement that the individual has to have insurance, etc.? And then hopefully once you've thought about that, and you've got your contracts in place, the final point, are you meeting your obligations, will be covered, because your contracts will say what the holiday entitlement is. You'll know whether they cover minimum wage, etc. But you almost need to do a mini audit now of everybody that you engage with and how you engage with them, and making sure that your contract reflects what's happening in practice. And then, then we've just got any more Q&A?
Okay, thank you, Elaine. I'll add a few that's in the chat box, and then we'll just see if anything comes through. And if we don't get through them all, we'll follow up afterwards. So I've got one here: is clubs taking on bar staff with no contract, use as and when, with no guaranteed work. I know these are very specific, and I appreciate that it's giving us sort of a guide. What status is this person?
If there's no guaranteed work and it's genuinely flexible, that to me sounds like you'd have them as a worker. What you need to make sure is if they don't become your favourite person who you're regularly rotating on, and they become an employee over a period of time. But if it's genuinely flexible, genuinely casual, worker.
Okay, another one in the employment field: employment contract, have staff with no contracts, been employed for years, and he doesn't feel like he needs one. Should we insist he signs one?
So if this the individual won't sign it, or the club would?
I believe looking at it, and if this particular person comes back in with more information, I think they've got somebody, clearly must be on a verbal contract. I'm making an assumption here, and he's obviously been on a verbal contract for many years. The club's saying, should we insist that they actually put something in writing with them?
Yes, you should. Just so that you're on an equal footing. And as I said, if the relationship sours in the future and he was to bring a claim, he could then tag on an extra claim to say, I've never been given a valid contract of employment, and he'd get 2 to 4 weeks compensation. He doesn't have to sign it, so you could almost do it as a letter to say, we've done a review, we just want to recap on your terms to make sure we're both on the same page, here it is. So you could still comply with the requirements of issuing the contract, but try and do it a bit more mooted, if you like. So not go overly formal and say, you've got to sign this in duplicate and return copies to us. You can do it passively.
Okay. And I've got one right. I'll go through all the ones in a minute, but I got one right at the beginning, which might require a bit more information. But the first question that was posted is that if a coach goes into a school to say run an after-school club and/or a half-term camp at the club, can we pay them to help them cover their loss of earnings? Now, there's not an awful lot of information there, but the assumptions I'm making is the person doing it in their day job is self-employed. What would the situation? What could the club do? I'm assuming it's a yes, but what would they need to think about in doing that properly?
I think then the club would have to be involved. So, for example, the school would have to contract with the club potentially, and then we'd subcontract work out to the individual. It really depends upon how the work's come in and how involved we want to be in it. And if we do want to support them, and we want to do it almost like we're helping the community as a school outreach, and we're happy to contribute some of the cost, you just have to think about, are you doing it as expenses? So it's not that we're paying for your hourly rate or your time, or actually, do we want to give you almost like a fixed fee for that work? So I think we'd need more information on that. It's possible, we just need to.
So I think the answer to Nick, if you want to put any more in, I'll come back to us, Nick. I think the answer is yes, you can. Obviously, therefore, in doing that, it depends on the circumstances. I've got one here. I think it's probably linked to the minimum wage. A question. It's over two. How does the London living wage affect minimum wages? Does that?
I'm not sure. We might need some more information on that. So you do. The London. Do you know what? The London living wage. Whoever sent that in, can you just give me an example of what you're querying, and we might pick that one up afterwards, because I might just need to run through a couple of points on that. But we'll follow up. If you let us know who it is and what your scenario is that you're thinking of, then we'll come back to you with a detailed answer.
Okay. And then I've got another one. Are people deemed who are deemed to be workers still subject to PAYE and NI deductions?
Yes, they are. So it'll still go. They'll be on your payroll. They'll still go through the payroll in the usual way.
Okay. Hang on. Let me just see if there's anything else cropping up. Okay. Do workers again in the situation of workers? Do workers accrue rights to notice and redundancy?
Workers won't for redundancy, but they do have the rights that we've put on the screen. So they're still entitled to notice, because that's a contractual claim, and they'll have all of the rights that we included on the screen. But no, they won't be entitled to redundancy.
There's a question I think probably aimed at us here at the RFU. So where is the best place to get contractor for employment? Do the RFU have a standard contract? In terms of players, yes, that can be found on our website under player registrations. I think Nia's put into the chat functions that there is an employment contract template available on the RFU legal portal, which is run by Irwin Mitchell. I think that the link is there, so that answers that. So I think, within reason, that's covered them all, Elaine. So I would just reiterate, say thank you ever so much for this evening. There's some really interesting points there, and just to reiterate that, guys, it's really certainly the point that was made earlier about HMRC looking at some of the rugby clubs in terms of the directors of rugby and coaches, and in terms of how they are, in terms of the status, is just worthwhile keeping an eye on. But please, you've got Alex and my details. If anybody's got any further questions, bounce them in, and I'm sure we'll get answers to you. So thank you.